families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to this week's edition of Families Divided TV. In this episode, we're going to be hearing from Canadian attorney Brian Ludmer and retired Israeli judge Philip Marcus in regards to parental alienation in the courts, both nationally and internationally. We're going to also hear from Dr. William Burnett. He's going to be bringing some important information to us about including parental alienation in the DSM-5 TR. I know you're going to be getting a lot out of both segments, so you may want to take notes. We'll be bringing these to you right after these messages.
Hello and welcome to this segment of Families Divided. Today, I'm happy to tell you that we have with us Judge Philip Marcus from Jerusalem, Israel, and attorney Brian Ludmer from Toronto, Canada. Welcome, Philip. Welcome, Brian. It is a pleasure to have you here today.
Great to be here.
Yes.
So we're just going to go ahead and jump right into this because I think that you guys can give our audience so much information about these really important topics of parental alienation. So the first question is, as a judge and as an attorney working in the field of PA, what are the biggest challenges that you see?
So it depends on where you are. There are some countries and some jurisdictions where cases involving parental alienation are dealt with competently and efficiently because there are specialist judges who understand what's going on, where the lawyers find it difficult to manipulate the judge because the judge knows as much or more than they do, where there are experts who are appointed by the court rather than by the parties, and where the issue of parental alienation is known to everyone, including the damage it causes to the children and, of course, to the excluded parent. However, there are jurisdictions, and I'm afraid there are many, probably a majority of jurisdictions, where judges may be sitting in the family court even though they don't want to, either because they've been rotated through family court in order to move ahead, or as one judge told me from India, sitting in family court is regarded as a punishment. These judges have little knowledge and little interest in family cases. And in those cases, it's very hard to get an efficient handling of these cases, simply because the judges and the court administration are unaware of how urgent it is to handle these cases efficiently, how important it is to get them before a judge immediately, how important it is for the judge to manage the case rather than have the lawyers manage the case for him, and where there is little awareness of the importance of the voice of the child, the voice rather than the choice, so that the child and his lawyer are not enabled to line up with the alienating parent. So my work, as I'll explain later, includes intensive training for lawyers and for judges in order that these cases can be dealt with more efficiently and in the interests of the child, rather than just general run-of-the-mill civil cases where there's a winner and a loser. In cases involving parental alienation, the child is always the loser.
So that is fascinating. The idea of a punishment to go to the court or moving along with their career, and that's a fascinating insight that we don't have here, or maybe a perspective we don't have here in the United States. I know in our state the judges get voted in to their positions.
So let me just explain. In Israel, in order to be a judge in the family court, you have to have experience and knowledge in the field as an attorney. And you're only appointed to the family court if you agree to be appointed. A person who doesn't want to be in the family court will not be assigned to the family court. There are, of course, smaller jurisdictions where there may only be 2 or 3 judges in a particular area, and then one of them will take on the family cases. But that can be partially overcome because any judge who hears family cases has to attend a compulsory seminar, 3 or 4 days residential every year, and cases involving children are addressed in those seminars with lawyers and psychologists and psychiatrists and social workers addressing and keeping the judges up to date with what's involved, what ought to be the correct conduct of cases involving children. That's something that I recommend that other jurisdictions should adopt.
Absolutely. So, Brian, same question to you. What are some of the challenges for you as an attorney?
Well, just building on some of the comments from Judge Marcus, you can have the knowledgeable judge or a judge who really doesn't have specialist knowledge of this dynamic, even within a country, within a province or state. These cases are the most vexing of the high conflict cases that judges are going to have to deal with. And many of the experts in this area have written about the counterintuitive nature of PA, where the first reaction to such a dysfunctional parent-child relationship is that parent must have done something terribly wrong for the child to act in this manner. Whereas someone with much more experience would be intrigued and would know the research that even children who've been demonstrably abused to the point that they're in foster care still want contact with their parent. They hope it's going to be different, of course, but they don't totally wash their hands of the parent. So it's a problem everywhere. And therefore, it's up to the attorney in a lot of cases to educate the court. Educating the court requires time, hard to do on a motion, hard to do in a short trial, which necessarily means that in these intractable cases, you're looking at very lengthy trials, and there are times and there are jurisdictions where because of court backlogs or just style of how they deal with cases, you're just not going to get a 3-4 week trial to prove this out and have room within the trial to educate the judge, etc. So that's a perennial challenge. The day-to-day challenge is there's 2 competing narratives in these cases. It would be hard enough to establish, because of the counterintuitive nature of PA, what's really going on. What is the authentic child really stating? And how do you explain the child's behavior in terms of the authentic child within, as opposed to how the child's presenting? Add in the second narrative, the competing narrative, offering a full rationale for why what we call the targeted parent has such a dysfunctional relationship with the children. And then try and imagine if you're the adjudicator figuring this out. So a lot of times they're just ducking and running and trying to punt it over into a therapeutic environment. And of course, traditional therapy is actually contraindicated in these cases. It will do more harm than good. It will just serve to be yet another battleground for who's right. You need a very structured, directive intervention meant to support an existing parenting plan that is actually not therapy. That's quite a deep topic for another forum. So you do need some sort of on-the-ground intervention out of court, but it's not therapy. And very few people other than specialist therapists even know how to describe that, let alone construct it and implement it. Mm-hmm. So that's a challenge. The therapeutic community itself, the mental health community, usually does not have the knowledge and experience to help with these cases. So in upshot, a lot of education and a lot of conferences and publishing and standards are required.
So it sounds like for both of you, one of the biggest challenges, whether it's here in the United States or internationally, it's education. Education seems to be the foundational piece of which it is that we all need to really get on board with and start moving forward, from the counselors to the attorneys to the judges, and to move this PA forward. I usually call it an epidemic because that's how I kind of think of it. So Brian, back to you, like with regards to the work that both of you are doing in Parental Alienation, what are you currently working on?
Obviously, the caseload itself, each case that has a successful result, each case that has an insightful judgment, particularly the Canadian style of writing where they're quite lengthy and dense and serve as a teaching tool in and of itself. That occupies obviously the bulk of my time. But I do a lot of speaking, and I do a lot of work with various organizations in the field, and I do a certain amount of advocacy work in the realm of equal shared parenting. And I provide a lot of assistance to other lawyers. So it starts to become well known who has a lot of experience in a very difficult field. And I'm only too happy to provide insight and precedence. And so I've been able to touch more children through acting as a consultant on other people's files, and have a hand in saving more children that way. So those are the things that occupy the bulk of my time. And these cases are generally put on a trial track for the reasons that I said. They shouldn't be. There's a fair body of law now that says you need to intervene at the earliest stages with some of the structural remedies in the family, and don't just say, well, that sort of remedy you need a trial for. If you try one round of a therapeutic type of intervention, then if it fails, you got to try a structural intervention in the family. And I think more judges are coming around to that understanding. The last piece is I am involved in some of the research that is going on in the field. I'm involved in a paper that will be published surveying Canadian cases in terms of some of the controversies in the field.
Oh, well, that is fascinating. Do you know when that's going to be published so we can all kind of keep an eye out for that?
Probably before the end of the year.
Oh, well, that is fantastic. Thank you for all that you do to help move this forward. And Philip, what things are you working on?
Well, I have the distinct advantage of being retired from the bench. I retired specifically in order to be able to engage in research and writing and advocacy, mainly for children whose parents are separating and divorcing. The perception is that I think needs to be made clear to everybody, is that a child who grows up where the parents are not working together as spouses does not absorb a normative idea of what is a spousal relationship. If they're fighting, then of course he is seeing an even worse example of how to relate to a partner. If he is the object of fighting, then he's not seeing a normative child-parent relationship. And as a result, he is, when he grows up, he's going to have incompetent spousal relationships and problematic parenting relationships. So that every child whose parents are separating or divorcing is going to have trouble unless the parents do the separation and divorce with the child's needs in mind. So one of the projects I'm working on here in Israel is to produce a document which will be distributed to couples who are thinking of separating, and encouraging them to see the needs of the child against or over any interpersonal issues they have. And the first person they should see is not a lawyer. The first person they should see is a counselor, someone who's experienced in the field. So that's one area that I'm working on. The second area is training and education. I put these in two different categories. I think that students of social work and of law and of psychology and of medicine and of education need to know about that there is such a thing as parental alienation, that it is in fact child psychological abuse, that its effects are terrible. And so I'm lecturing to students in various places about that. What that means is that when they do qualify in their profession, they will have at least a sketchy knowledge of what's going on, and they will understand how serious these cases are and how swiftly they need to be dealt with. A third area is advising different jurisdictions about how to reform their family law, particularly in order that co-parenting should be the rule rather than the exception, and that couples, even after they separate, still have the same responsibilities to their children, to look after their children. The next area is family court reform. I think that in Israel we have an excellent family court system, specialist judges, as I've already pointed out. There is a social services unit attached to the court which advises the parents and the court where necessary and can divert them to non-adversarial methods of dispute resolution. And there are other advantages, and I am suggesting in the places where I'm invited, and even when I'm not invited, that they ought to adopt a system which is closer to the Israeli system. There's a further area which is prevention. That's in two parts. One part is that youngsters should be taught about relationships and how to form correct relationships. And the last part is research which is intended to show the economic cost of parental alienation so that governments will invest more money in prevention programs and thereby save a huge amount of money in cleaning up after there has been alienation. So those are some of the things I'm working on.
Oh, just a few. It sounds like a ton. Both of you are so deeply involved in the prevention and the research and the writing. That is wonderful. And I'm sure all of us out here will be beneficiaries of those things. So we have about a minute or two. We have 2 minutes left. So just real quickly, Philip, we'll start with you. What are the challenges in demonstrating in courts that PA is child abuse? And this might be a longer question than we had hoped.
Well, it turns on what I was speaking about. It turns on training. It turns on awareness. It turns on public awareness, but also the awareness of those involved. I haven't sat in court now for 10 years. 10 years ago, there was a lot less literature on the topic. There was a lot less known on the topic. But what I can say is that, as Brian correctly mentioned, these cases have to be given priority. In Israel, as you may know, the President of the Supreme Court issued a practice direction that any case in which there's an allegation of abuse, including parental alienation, has to come before a judge within 14 days of filing. Both parties have to be there. The court at that point is empowered to appoint a guardian ad litem for the child, and also to order reconciliation processes after investigation. The underlying theme is that a child needs both parents. And it's a very heavy burden on one of the parents to prove that the child does not need the other parent. So the presumption is contact. The presumption is help in co-parenting, help in therapy for the child. And those are the things which ought to be emphasized before the court.
This has been great talking to both of you gentlemen today. So much information, so informative. I think those of us that work in parental alienation field are so blessed to have both of you on our side and moving forward with getting the information out and making sure that people are students of their profession and that we're equipping and arming the professionals.
Don't forget to subscribe to the Families Divided TV YouTube channel. There you'll find all of the past episodes of Families Divided, plus more exclusive content on parental and grandparent alienation. When you subscribe to the YouTube channel, you'll receive notification when new content becomes available.
Hello, I'm William Burnett. I'm a child psychiatrist and a forensic psychiatrist in Nashville, Tennessee. Today, I want to tell you about a project that my colleagues and I have been working on. In particular, what we're trying to do is we're trying to have parental alienation included in the Diagnostic and Statistical Manual of Mental Disorders. In other words, that's DSM-5 TR. That's the book that psychiatrists use for all the diagnoses of mental problems. So here's the book. This is what the DSM-5 TR looks like. And what we want to talk about today is the condition that we're calling parental alienation relational problem, or we call it PARP, and that we want that to be included in this book. So let me go over the definition. This is the first part of the definition of PARP, and let's read it together. This category may be used when a child, usually one whose parents are engaged in a high conflict separation or divorce, allies strongly with one parent and rejects a relationship with the other parent without a good reason. So this is the second part of the definition of PARP, because here we list the criteria. We say the diagnosis of PARP usually requires 5 criteria. The child avoids, resists, or refuses a relationship with a parent. Second, there's been a prior positive relationship between the child and the now rejected parent. Thirdly, there's an absence of abuse or neglect or seriously deficient parenting on the part of the now rejected parent. Fourth, there's the use of multiple alienating behaviors by the favored parent. And fifth, there are manifestations of behavioral signs of alienation by the child. So those are the 5 criteria that have been established for the diagnosis of parental alienation, or what we're calling parental alienation relational problem. And these 5 criteria were recently published in an important article in a journal, the Journal of the American Academy of Child and Adolescent Psychiatry. So it's pretty clear that those should be the 5 criteria for the diagnosis of parental alienation relational problem. Well, this is a big project, and we need help to make this happen. So what we're doing, my colleagues and I, we're asking individuals and organizations to endorse the proposal that PARP be included in the DSM-5 PR. We've already been at this for a while, and we have more than 1,000 endorsements, some of them from individuals, some of them from groups or organizations. Like, for instance, various advocacy organizations have endorsed this project. So we're asking that if you want to help, you can do that. So this is what you can do. You can contact me at this address here, william.burnett@vumc.org. That stands for Vanderbilt University Medical Center.org. And first of all, if you want to see the whole proposal, I mean, I just told you the little part about the actual definition, but the proposal has all the reasons why this is a good idea. So if you want to see the actual proposal, you can contact me. Or secondly, if you want to endorse the proposal, you can contact me. And you can do that if you're an individual. For instance, you can be an alienated parent or a grandparent, or you can be a therapist or an attorney. If you want to endorse the proposal, you can contact me. Or if you want to see the entire proposal, I'll send it to you. So thank you very much for your attention. And I hope you can help us out with this project.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Is shared parenting a magic bullet against parental alienation? Dr. Don Hubin tackles that question next week on Families Divided.